What is a plaintiff? On a very basic level, a plaintiff is any person or entity who initiates or files a lawsuit. In most legal cases there are two primary parties. The plaintiff, sometimes also called a claimant, is the one who brings the case, and the defendant is the party against whom it is brought. These names are also usually consistent with the roles of prosecution and defense. In nearly all cases, people must actively choose to file a claim, or else intentionally join a group of joint claimants. In a sense, then, the role is voluntary. Sometimes governments and other public organizations will also initiate cases. Depending on the nature of the claim, it may be possible for the parties to settle their dispute out of court. If things progress to a trial, the prosecution usually has a defined list of responsibilities when it comes to presenting an argument and providing evidence. Most legal systems allow parties to represent themselves, but most people, particularly in complicated cases, choose to hire attorneys. Most trial lawyers are specially trained in the needed nuances of filing papers, presenting files, and negotiating favorable outcomes. Many community legal groups and bar associations can provide references to people who may be interested in filing claims or bringing cases with the help of a skilled representative. Most legal disputes have two main sides, one that claims to have been injured or damaged, and another who is alleged to be the cause. In the simplest cases, each side is represented by a single party. More often there are many different people, companies, and groups involved, which can make things more complicated. Even still, there is usually just one lawyer or attorney who serves as the primary representative for each, which can streamline negotiations and courtroom proceedings. In most places, legal actions begin when one party files a formal complaint and petitions the court to hear the dispute. Almost by default, the person filing then becomes the plaintiff. Of course, simply filling out paperwork doesn't guarantee a trial. The court usually must decide whether or not to hear a case, based on things like overall merit and whether all filing requirements have been met. It's also possible that the person against whom complaints are made can countersue, which is basically to make allegations back. In this scenario, it is theoretically possible for one party to be both a plaintiff and a defendant simultaneously in closely related cases. There are many different examples of how people can assume these party roles, but a common one arises when someone has been injured in a motor vehicle accident. If the injured party lives in a jurisdiction where he or she has the right to sue, he or she may be able to bring an action to receive a monetary payment from the driver or an involved insurance company to compensate for lost wages and medical expenses. The injured person may also be entitled to a payment for pain and suffering, though this usually has to be proved pretty specifically. A person may also become a claimant when he or she is seeking compensation for personal injuries caused by faulty products or medical malpractice. In addition, actions may be started to recover unpaid debts or in cases of alleged fraud. Family members might seek damages in a case of wrongful death, too. Different jurisdictions have different rules when it comes to the process of beginning a lawsuit. When a person feels that he or she has been wronged and is looking for compensation, it is usually wise to consult an attorney. These trained legal specialists work on behalf of clients to recover monetary damages. The attorney provides appropriate legal advice and attempts to negotiate the best possible settlement of the legal dispute for his or her client. The attorney will prepare legal documents that set out the basic claim against the other party or parties. He or she will also arrange to have the papers served so that those being sued are aware of the claim being made. It's not usually enough for the wronged party to make allegations that they have suffered a loss. He or she must also have evidence to support the claim being made, and also usually has to follow a number of often very specific administrative rules. Settlement is usually regarded as the best possible solution, since it forces the parties to come to a mutual agreement and avoids the stress, time, and expense of a courtroom appearance. When entered into properly, settlements are usually just as binding as a judge's ruling. In cases where it isn't possible to settle the claim without going to court, the claimant or his or her attorney typically takes charge of the proceedings. With very few exceptions, the claimant's side presents first, after which time the other party is given the opportunity to present a rebuttal or defense. If the judge determines that the wronged party is entitled to damages, he or she will enter a judgment for the plaintiff. Otherwise, the judge rules in favor of the defense.